Members, last year, Representative Edmund Jordan had introduced legislation to amend the Louisiana statutes dealing with qualified immunity. His legislation did not get through the process, but I committed to him, and I got Speaker Schexnayder's commitment that we would look at this and have meetings in the interim. In the meantime, Senator Cleo Fields had sponsored SCR 7, which provided with to look at police training, screening, and de-escalation. So they had multiple meetings with members from throughout the law enforcement on both sides in government, and they did a lot of the heavy lifting, and Representative Jordan was on that task force in which he chaired the subcommittee on statutory qualified immunity, and they made recommendations to the task force, and the task force, the SCR 7 task force, has adopted those recommendations. So as I said, a lot of the real heavy lifting has been done, and one of the things was they agreed to make recommendations to alter the doctrine of statutory qualified immunity, and they have made recommendations to amend the three statutes, 92793.1, 92798.1, and 92800.10. So what I foresee this committee doing is hearing a little bit about the doctrine of qualified immunity, asking members of the public and members of the different agencies and stakeholders if they would like to present and give us their view of this. And what we're dealing with is just the statutory state qualified immunity. We can't affect all the other areas, but this is one area that we do have jurisdiction over. Secondly, anything dealing with this is going to have to come through civil law anyway. So figured we'd get a head start on looking at this so that when we come to hear this during the session, if a bill is introduced or bills are introduced, we will have had some background with that. So with that, I would ask just for staff, either Miss Annie or Miss Amy, to give us a little overview of the qualified immunity doctrine. So Miss Peardle.
Right. Thank you, Chairman. Members, qualified immunity is a concept of giving police officers civil liability immunity based upon their status as a police officer. It can arise from both federal and state sources. Federal qualified immunity is a judicially created doctrine that shields government officials from being held personally liable for violations of civil rights, as long as those rights were not, quote, clearly established at the time they were violated. The protected constitutional right must be sufficiently clear that a reasonable official would understand that what he was doing would violate that right. In claims against public employees pursuant to state law, public employees may take advantage of 3 civil liability immunity defenses as established in Title IX of the revised statutes. 2793.1 provides for immunity for public entities for damages to property at the site of the crime, accident, or fire, as long as the employee was acting within the course and scope of their office or employment and taking reasonable remedial action to abate a public emergency. 2798.1 provides for immunity for policymaking or discretionary acts or omissions for public officials. Finally, 2800.10 provides immunity for liability while injuries sustained by a perpetrator of a felony offense during the commission of the offense or while fleeing the scene. It does not extend to the injury or death of a perpetrator resulting from an intentional act involving the use of excessive force. And members, a memo regarding all of these above statutes was sent to you. On January 14th, 2021, the Police Training, Screening, and De-Escalation Task Force met pursuant to SCR 7 of the 2020 First Extraordinary Session and adopted a recommendation to add language to 3 Louisiana statutes providing a limitation of liability to law enforcement officers. and that is 2793.1, 2798.1, and 2800.10, to prohibit the element of qualified immunity from being available to law enforcement officers as a defense to liability for claims brought under state law for wrongful death, physical injury, or personal injury inflicted by law enforcement officers through the use of any physical force in a manner determined to be unreasonable by the finder of fact in a judicial proceeding. The task force recommendations were emailed to each member of the subcommittee prior to this meeting as well.
Thank you, Ms. Pearson. So with that, we have several. I see Professor Ray Diamond has walked in, and I think he's kind of got the scholarly view of it. And if he would be so kind as to come to the table and maybe give us a little briefer on the doctrine of qualified immunity and any issues that you see specifically as to Louisiana statutory qualified immunity. And I believe Professor Diamond was also a member of the task force that made these recommendations. And good morning.
Good morning, Chairman Miller.
Good morning.
And thank you. Thank you for having me here. And I want to speak first as a member of the task force. I started with this task force.
Just first identify yourself and your affiliation, if you don't mind.
Certainly. My name is Raymond T Diamond. I am a professor at Louisiana State University's Law Center. I've been teaching constitutional law and criminal law for 37 years, although I hope it doesn't look that way. I came to the task force as a scholar of race and the Constitution and legal history and the nexus among them. So I came to the task force, I think, in a learning mode and less of an expert and more of someone who was desirous of achieving some solutions to a problem that many of us saw. Again, I came in learning mode, and some of the things I learned had to do, and this I think confirmed some of my initial biases. So what I learned had to do with what I think is an intersecting set of possible solutions. For example, in the training process, we can train police better not to do some of the things that concern us. With respect to the disciplinary process, we can put in place disincentives that will convince police not to do some of the things that concern us. And I think similarly in the tort realm, although qualified immunity is clearly a function of, and the creation really, of the federal courts, it has a very odd provenance out of some of the Reconstruction era legislation meant to give tort relief to those whose constitutional rights had been violated. The court nonetheless created the doctrine of qualified immunity. That is, unless a state official it was absolutely clear that what the state official had done violated someone's rights, then that state official had what's known as qualified immunity. If someone did that exact same thing tomorrow, there would be no qualified immunity because they would be on notice, but not yesterday. Now, as a personal matter, I think that this was a matter of the federal courts consciously undermining the civil rights legislation and the 14th Amendment, which it was meant to to enforce, but such is the power of precedent such that that lives with us today. Now, in state law, qualified immunity works in somewhat the same way, and our intention here is not to undermine federal law. You would not, as a legislature, be able to undermine federal law, such as the lesson of the Supremacy Clause. But to the extent that qualified immunity applies in state law, our idea was that we could, how should I put this? We could provide a financial disincentive both to officers and to the departments, the sheriff's office, the police departments that they work for, by emplacing a bar to qualified immunity. Now, how would this work? What it would mean is that a police officer who violated the rights of an individual would be liable, irrespective of the former, we hope, doctrine of qualified immunity. Yes, this would mean that various jurisdictions would be subject to tort suits, but what it would also mean is that those jurisdictions would have more of an incentive to police their own police. It would mean that police officers would find themselves under pressure from their own departments. Sheriff's deputies would find themselves under pressure from the sheriffs to behave in a manner that doesn't cost the jurisdiction money. Now, one of the things that we saw in our hearings is that there is a recognition both from the right and the left that this is a possible solution to the problem that we see. I speak as a confirmed capitalist when I say that if we incent certain behavior, we will get more of it. If we disincent behavior, we will get less of it. And so I think there's possibly a market approach here. I may be going beyond the call of your question, Representative Miller, but I think that perhaps there's a market approach here in that whether we are self-insuring or whether, on the other hand, we are buying insurance in the private market, public bodies have an interest in keeping our rates low. And so what that means is that we're going to have, I think, more in the way of supervision, of training, of avoidance, of officers being conscious of their own activity. And why is that? Not just simply because it's a matter of good government, but because it's also a matter of the pocketbook.
Thank you, Professor Diamond. I don't know if with the Texas utility situation with this storm, I don't know if the market approach is might have some pitfalls, but you're not advocating a complete unfettered, Wild West type situation, and you're.
Oh, not at all. If I may use an example that I used when speaking before the task force, I use as an example my mother, who at 94 is still with us, and at 90 quit driving. Why was that? Not because she'd had an accident, not because she'd ever had a ticket, but because the cost of insurance was so high. She was priced out of the market because she represented a risk. If we're lucky, we all get to that point. Now, similarly here, I think if an individual officer's conduct becomes so risky and represents a danger to the pocketbook, either of a self-insured fund or an insurance company, there will be market pressure on the department or the sheriff's office in addition to everything else. There'll be market pressure that's put on that office because the insurance rates will skyrocket if they have too many people doing too many bad things.
Okay. And just, from my impression, the doctrine, I think, seems to, we want to avoid having a situation where, police officers, officials, and the people who employ them are constantly having to defend lawsuits and having to expend public funds in a lot of different areas, so that they want to narrow the scope of what they would have to defend and leave that to where the most egregious conduct is. That, I mean, that's my simplest way of kind of looking at the doctrine, that we don't want to have, for example, in workers' comp, we have trade-offs in terms of, you can't get damages for pain and suffering, and you have different schedules, you get your medicals, but you also don't have to prove negligence. And this is kind of a obverse way. You have to have a fair. They have set a high bar to discourage a lot of lawsuits for things that an officer may be doing in the course and scope of his work, where they don't want to just be having to defend lawsuits every time something negligent happens to someone perhaps who they are trying to arrest.
Well, I do see that point, Mr. Chairman, but I will suggest that the doctrine of qualified immunity goes beyond protecting against all but the most egregious conduct. The jurisprudence that underlies qualified immunity allows absolutely awful, horrendous conduct to go without tort liability, simply because nothing like that in particular has ever happened before. So I think that is where the doctrine has taken us, and it was the judgment of the task force that we need to take a step away from that. Nobody's interested in bankrupting the police department. I think what we're interested in, what we were interested in on the subcommittees that I had association with, what we were interested in is in placing a disincentive toward lack of supervision and lack of correction. And I would offer something else. I would say that there are some torts that police departments ought to be responsible for. It's not clear to me that every minor tort that's committed by a police officer would be the subject of a lawsuit. How many times have one of us been bumped, and you look at your bumper and you say, oh, there's no problem, and you walk right along because it's simply not worth your effort. For those of us in the room who are lawyers and who've been plaintiff lawyers, how many times has there been some minor issue that has been brought to us, and what we recognize is it is simply not worth the effort to achieve compensation for the victim. So I think, we're speaking of markets. Lawyers, the plaintiff's lawyer market is a market. It is responsible to those kinds of it is responsive to those kinds of economic realities. So my concern is that the doctrine of qualified immunity, as we have come to know it, goes beyond the protection of the egregious, or perhaps I said that wrong. It does not go so far as to protect against against liability for egregious conduct. And again, that was the interest of the committee.
So it's not necessarily the idea, the doctrine of qualified immunity. It's how it has been interpreted and applied by the courts is what that it's protecting too many acts that should not be protected. Is that fair to say?
I think that's fair to say. And without, and I hope this doesn't undermine the committee, the task force at all. You as a legislative body have choices to make. Now, it could be that the choice you would make is the choice that we offer in this proposed bill. It could be that the choice that you would make is to alter the doctrine of qualified immunity as opposed to ridding us of the doctrine of qualified immunity. I think both would be a step forward. I do, however, stand with the task force in offering our recommendation as what we think to be a preferable one.
And you served on the subcommittee chaired by Representative Jordan on the qualified immunity, and y'all submitted and approved the language that we're looking at today.
Yes, we did. Okay. Yes, we did.
Okay.
And I must say that I was surprised at the level of consensus that we were able to achieve. You are aware of the membership of that subcommittee, and we took into account the interests of the police and the sheriffs. We also took into account the interest of the community. I was surprised, I must say. But the other thing I have to say is it's a recognition. What we were able to achieve is a recognition of what surrounds us. Of what is on TV, sadly, all too many nights. Just yesterday, that poor young man in Colorado was determined to have been stopped without any warrant, and of course we know he has died from it. There's a staccato of effect of police misconduct. We think that this police misconduct is not universal, that it's only, quote, a few bad apples, but we see so much of it that I think we've come to a common realization that we have to do something. And I think that that is responsible for the consensus that we achieved among these disparate interests that were part of the subcommittee.
Okay, thank you. Do the members have any questions for Professor Diamond? So, all right.
Well,
with that, really appreciate you being here.
Thank you.
Of course, you're welcome to stay, and if something arises, we'd love to be able to call you back.
Well, I will stay for a few minutes. I've arranged with my students that this work is important too. So,
well, we appreciate you rearranging your schedule to be here.
Thank you very much.
Thank you. I see Representative Jordan has come in the room. Representative Jordan, would you like the opportunity to say a few words? Since you were you chaired that subcommittee and you did the heavy lifting along with the subcommittee members on the task force. Good morning.
Good morning, and let me apologize. That was a delay on the bridge, so when you live on the other side of the river, sometimes you got to deal
Which bridge did you use?
You know what? I tried using both, but the old bridge, the new bridge was backed up. I said, well, I'll go to the old bridge, and it was completely closed, and then had to come back around. So anyway.
There's a bridge further north, further upriver.
Well, look, if I had to go all the way to Donaldsonville to use the bridge or the ferry, you'd still be waiting on me.
Thank you for being here. Appreciate it.
No, so, and look, I was listening the whole time, so I don't know if I could say it any more eloquent than what Professor Diamond did, and I certainly want to thank him and all the members of the task force for all the hard work that was put in on this. I tell you what, it wasn't an easy job, but it was one that we thought was necessary, And I also want to thank the Sheriff's Association, the Police Chiefs Association. I think we had a pretty good group that came to the table with some openness and some willingness to try to resolve the issue. I don't want to speak for them because they're here. I see Mr. Renat's in the back and some others, so they can certainly speak for themselves. But I'd like to say I think everybody recognizes that this is an issue. I'm not sure everybody back in June, everybody really appreciated the magnitude of the issue, even in light of George Floyd and Philando Castile and Breonna Taylor, and I mean I can go on and on and on. It is it's a challenge for me sometimes when I hear some of the comments, and again, I was listening in, and I want to be clear. This is not an indictment on all law enforcement, and we certainly aren't trying to open up avenues where police officers always have to second guess themselves in whether or not they're making the right decision. But I certainly would like to juxtapose that against the issue of just black humanity. And I hate to, well, I don't hate to say it that bluntly. I mean, that's what it is, and for me, that is something that is not up for compromise or debate. So if I had to choose, and again, I don't want to send the wrong message out there because I don't want anybody to walk away saying this is what we wanted. But if I had to choose between law enforcement providing better training, policing themselves, making sure that their officers are not out there committing egregious acts, and the safety of every citizen to be treated equally, I'm gonna make that choice every day. I don't think that's a hard choice for me to make. Now, that being said, we do know that there are limits to what we can do. And of course, I heard you, of course, we're talking about statutory qualified immunity. And so from that perspective, I think that we have something that's good. I can tell you I'm working with Ms. Derman at the Sheriff's Association. We're working on something that I think could be a little bit better. But I will assure you, if we don't have a compromise or we can't reach that, then I'll certainly let this committee know. I don't want to put the committee in a tough situation. Sometimes I don't mind doing that, but look, I think, and the reason why I say that because I think we've done enough work, and I think that we're so close that we can certainly reach the ends that we want to get to. So that being said, I'm certainly open to any questions. I want to thank Senator Fields publicly for creating that task force and having me as the chair of that subcommittee. And again, just thank all the members and all the people who participated. I think Chairman Miller, I sent you some information just so that we say this. This is not a conservative issue. This is not a liberal or progressive issue. This is really not a black or white issue, frankly. I've gotten the support of the Institute for Justice, which is a libertarian think tank, and Lee McGrath and those guys. I want to thank them. They've come on board. I want to thank the Americans for Prosperity, which is more of a conservative, headed, I think, by the Koch brothers, and the ACLU. So there's been a broad range of support and appeal for this, because the doctrine is just the way it is, certainly the way it's implemented is just patently unfair and unjust. But I think just even in concept, that somebody can have their constitutional rights violated and there be no repercussion or redress for that just seems unconscionable to me. But I do want to, again, thank all those groups, because I do think we have a broad range of support and appeal.
All right. Thank you, Representative Jordan. Anybody have any questions for Representative Jordan? So, sure, Representative Carter.
It's a general question. Just going over the recommendation. I noticed a couple of things that I wonder if y'all dealt with it. One thing y'all address is body cams, a police officer's body cams on a police officer and on the automobile,
The dash cameras, right.
dash cam, and with these search warrants situations, it's been my experience there's a lot of time that people executing the search warrants are not patrol officers. They're detectives and folks in task force, drug task forces and stuff like that. And when they conduct these search warrants, they don't have body cams on. Okay, and I thought it would be a good idea, and did y'all consider this, to have, when you execute a search warrant, especially if you have a situation where you can authorize a no-knock warrant still in exception situations, that they have body cam when they conduct these search warrants, so we have a record of what the officer did and how he went about finding the evidence that is the basis of the case. So did y'all consider body cams upon folks executing search warrants, no knock and otherwise? Okay.
Well, let me tell you. So let me start with the last part first.
Yeah.
We did address no knock warrants, and we do have some potential legislation coming with that. The body cam and dash cam situation, we really mostly focused, and if I'm misstating, Professor Diamond, please jump in and correct me. But I think most of that was focused on uniform patrol. Mm-hmm. So as it relates to detectives, I don't remember anything specifically to them. And I don't know if that issue was ever brought up that most of the detectives don't wear body cams. Mm-hmm. And so how would you address that situation? Okay. So that may be something we need to look into.
Yeah, I would just, been my experience as a judge of 21 years, that these search warrants, the flaws in them and the problems developing the motion suppressed, what have you, would be resolved, probably wouldn't exist if the officer conducting the search had a body cam. And so he would have a record of what he was doing. It's pretty much the same idea when you go to a crime scene, when you investigate the crime scene, you take pictures of everything, as much recording you can do, video and pictures of the scene. And so I think it's also equally important that we have these detectives, these task force people, drug task force people, have body cam on them, required to have body cam. Now, and I know that's a problem with funding, and we need to do something with that. Some departments may not have the funding, but the more prominent departments in the larger cities, the sheriff department, the state, the city police department, the task force officers, they get a lot of money they seize from criminals in this state, and they can easily afford a body cam. And if they had that body cam on them when they're conducting a search warrant, that would solve a lot of problems. That's just a thought. That's something. Maybe we can do something to the legislation that would address that.
Well, I would tell you, in the body cam discussion, surprisingly, it wasn't really about the cameras that they had an issue with. It's more about the storage. Yeah. They're saying that the cloud storage. You'd have to have so much space for that, and that's the part that actually becomes, I think, more costly for the departments, especially a lot of the smaller departments. I think we probably could find a way to get everybody outfitted with cameras, but then the issue would be, well, are we going to have like a consortium of departments, I guess, that would come together and store it in one on one server? Or how's that going to become it? How long do you have to keep it? And so I think the smaller departments, and even state police for that matter, had an issue as to what the cost would be in trying to implement something like that. Because part of what we had talked about was having it running all the time, and or when do you do it, and what are you redacting? I mean, there were some issues with that, but I think the discussion has started. So whatever ideas and thoughts you have on that, I think would certainly be welcome. So,
all right. Thank you, Representative Carter. Before I recognize Representative Freeman for his question, I just want to, should have done this before, but if anybody wants to speak, please fill out a card, white for information only, or if you just want to put put in that you're available here for questions. If you're opposed to whatever we're doing, I guess that would be red, but we're or in favor, a green card. But with that, Representative Freeman for a question.
Thank you, Mr. Chairman. Good to see you again, my friend.
Yeah, same here.
I really appreciate the work you've done on this, and I remember your testimony in the committee the last time, and listening to Professor Diamond. One of the things that I remember that I thought was really important, that I also had an issue with, is this court-created jurisprudence that says, if it didn't happen before, we can't find you liable for it now. And I do think that's a problem. And I guess my question's going to, I'm reading the changes there you are proposing to make to the qualified immunity statute. And the original statute was to protect against the egregious, willful, wanton actions, the high level problems. And of course, the courts, what they did with this not acting before has pretty much kind of let everything go, so to speak, and nothing gets punished unless it happened before, which, as you mentioned in your testimony, I remember saying, unless it happened exactly the way it happened once before, the courts are not going to allow it to go forward. And again, I do have an issue with that. But I also am a little concerned about where it's going when we take it down to an unreasonable standard. We're now, instead of what was originally trying to do, which was to prevent the wanton, reckless, negligent, egregious acts, we're taking those levels down. And I'm wondering why.
Correct. We're not really taking it down. That's always been the standard. So we're not really changing the standard. All we're really doing is doing away with the second prong of the test, because you always had to have the issue of reasonableness, and so that's not. So I just want to be clear: it's not lowering the standard at all. That's what the standard's always been.
Well, my question is, why wouldn't we be trying to attack and fix the court-created jurisprudence problem, which is what I think everyone is saying is a problem?
That's exactly what we did.
By changing the verbiage of this statute, yes, in a sense you are, but I think also this statute tends to lower the actions down to anything that's considered unreasonable.
But well, I understand that, but it doesn't. So, and that's why I want to make sure I stop that right there, because that's just, I hate to say it, but no other way, but that's just incorrect. So,
I've been incorrect before, so you're not offending me.
That's all right. That's all right. So because there's always been the reasonableness of a standard, and then once you get past that, then you get to the second prong of, was there prior notice? So all we did, in effect, was do away with the second prong that dealt with the prior notice, and so the first part of the test is still there. Didn't increase the standard, didn't lower it. Is basically the same.
I'll do a little bit more looking at it as well, but I appreciate your
Okay.
correcting me. Thank you.
Thank you, Representative Freeman. Representative Landry for a question.
Thanks, Rep. Jordan, for coming. I was very interested in reviewing the task force recommendations about the prohibiting the use of no-knock warrants under some circumstances. As we know, that's been a problem in this country for decades, and the situation with Breonna Taylor last year really raised the issue for many people. And I was wondering if you could tell us a little bit about what the task force discussed in relation to no-knock warrants. And I know you probably don't want to tell us exactly what you have planned, but what you think we might be looking at this year.
Well, look, I think there was, let me say it like this. Part of the discussion was, do we totally eliminate no-knock warrants, or do we do nothing? And I guess this is, and I don't have that statute in front of me right now, but what I would tell you is, when you look at it, you'll see that it's a compromise on those two different dynamics. So it would be used in limited situations, but but there's going to be, if you and I wish I had it in front of me, Representative Landry, because there were several states that had done some stuff prior to us even dealing with the task force, and they put so many different parameters on what you could go to the judge and what you could present prior to a no-knock warrant being issued. Thank you.
Thank you.
And members, I know you've got a lot of questions about what the task force did, but I hope we can try to keep it on task to the statutory qualified immunity, because that's kind of the province, the jurisdiction of this committee, civil law, and the subcommittee. So just keep that in mind. But
It is. I think they're substantially related, given that people are murdered in their homes and often have no recourse because of qualified immunity. So,
Yeah, so
sure.
I won't
I
be
see
very
that
long.
it's related. I know I just want for other members to let's try to make sure. And I see you. It does circle back to qualified immunity dealing with the no-knock
yeah.
warrants.
So let me just and look, I'll be very brief on it because and I'm glad. So part of it was, if you look in A, we talked about what you have to have the affidavit support going to the judge has to protect life or limb. One of the other big issues is identifying yourself, making sure that there's a clear identity, and then authorizing the use of search warrants only in the daytime, except for limited circumstances. Because, of course, because of like the Breonna Taylor situation, which happened at night, they don't announce themselves.
Fear.
That's right. Well, and of course, it becomes a, part of it is we look at this in the sense of danger to the potential victim, but we also, and especially in this situation, we look at it, and if you look at the Breonna Taylor situation, as protection to the law enforcement officers as well. Part of their justification was that her roommate shot at them. Well, if you're coming in at night, you're not identifying yourself. If somebody comes in my house at night not identifying themselves, what can happen. And then you shoot, and then they say, okay, you're shooting at me, now I'm shooting back, and it's law enforcement. I just think it creates a dangerous situation for the homeowner and for law enforcement. So we did that, and so and again, this is not something that we came up with and we're original and can take all credit for it, but we thought it was a good idea that had been implemented in some other states, and has already been. Let me say this: has already been passed. I think not only Louisiana, but I think other states are recognizing, as it relates to qualified immunity. Colorado has done something. I think Massachusetts has done something. We have other states. I think a lot of states are now recognizing the problematic issue around several of these concepts.
Thank you.
Thank you, Representative Landry. And it wasn't my intention to limit debate. I just wanted to make sure that we related to the qualified immunity. And I certainly can see where you have situations that arise out of a very expansive way of doing warrants that could lead to a lot of these situations that lead to a lot of lawsuits in which then qualified immunity would be raised. So, but again, thank you. All right. Any more questions for Representative Jordan? All right. Thank
Hey, look,
you.
you can call me Landry. Most time I get confused with Representative Edmonds, so I'm all right.
So
with that.
thank you,
I'll take
Representative Jordan. And with that, I appreciate you being here. And again, thanks.
Thank you, Chairman Miller, and I want to thank you personally for convening this meeting, because I know you and I talked, and you made a commitment, and I'm certainly thankful that you've honored that commitment. Thank you.
Thank you. All right, we have some cards. We have present and would like to speak Shannon Dearman, Louisiana Sheriff's Association. And we also have Mr. Mike Renazza from the Louisiana Sheriff's Association is present and will provide information if requested. Good morning, Ms. Dearman. If you just identify yourself and welcome.
Good morning. I'm Shannon Derman with the Louisiana Sheriff's Association. Thank you for convening this meeting today. Last year, when the original legislation was brought forth by Representative Jordan, it was a very difficult day in my career as an attorney, having to hear some of the stories and come and oppose the bill. But we hadn't had a chance to work together, and my commitment to you on behalf of the sheriffs at that time was to listen and to come to the table and work on legislation that we could move forward with that would hold bad actors accountable, while also ensuring that we could still bring good individuals into our profession as public safety officers and ensure that we wouldn't deter them from entering our profession. Since that time, Senator Fields' task force met. It was an honor to work with Representative Jordan, Representative Ted James, Senator Fields, stakeholders, and Professor Diamond, who also came and trained our sheriffs on diversity and anti-bias. Since I sat here at the table with you last year, we've learned a lot, and we proposed a number of things that will help build on our commitment to ensure that bad actors are held accountable. One of them was the revocation process through post. That's going to be one of the recommendations from the task force that you'll see this session. And then in addition to that, this was another tool, the qualified immunity language, which met our concerns. Representative Jordan was very open about listening to them, and we came to this language agreement that allows the finder of fact, a jury or a judge, to determine that the officer was in fact unreasonable, and then the analysis proceeds. But we wanted a way for the facts and circumstances to be analyzed according to current jurisprudence, so that we could at least determine the good actors from the bad. And I'm grateful to be here today. It's been a privilege to work together.
Thank you, Ms. Dearman. Anybody have any questions? Okay, we have Representative Jefferson.
Just a quick question. Good morning.
Good morning.
And you're absolutely correct. I remember that hearing, and after everything subsided, you were very clear in your willingness to work with Representative Jordan. And of course, I want to congratulate him on doing, with such passion, something that needed to be done. But two quick questions. Number one, as we're going through this, my main concern is those rural areas where, training and insight is going to be difficult. How has that been perceived as you've presented the work to the contingency of all of the sheriffs? And number two, as it relates to that training, how difficult do you think it'll be? Because in rural areas, it's tough just to find. I see Ms. Runt coming forward when we have so many new sheriffs coming at this time. So how are we going to balance that per se? Because I think that will assist us as we go forward. And then this was the second aspect. You mentioned looking at the unreasonable aspect and then being able to proceed. Are you all comfortable with where we are regarding what has been proposed and then being able to proceed without, because it didn't happen prior at that point?
Yes, I think we work together on the language. I think it allows the reasonableness standard to be addressed. And I think it's important to distinguish the federal case law, the federal test is still on the books, and this is the statutory provision that we work together on. So we are comfortable with the reasonableness standard in the language now. And then because of Mr. Renazza's involvement in post, I will let him answer that question.
Good morning.
Good morning, Mr. Chairman, members. Michael Renazza, Executive Director of
Please
Louisiana
mic down a bit,
Sheriff's.
Mr. Renazza.
And thank you for the question, Representative Jefferson, because it certainly matters that we support this as an organization. So the vehicle in which we're going to do that actually starts tomorrow, when we will meet with our Legislative Operating Committee, chaired by Sheriff Doug Hebert from Allen Parish. So we will have that body go over those recommendations, and I will be presenting the 18 recommendations that came from the SCR 7 committee, which I actually sat on and voted for each of those recommendations as well. So I want to emphatically tell you that as Professor Diamond spoke, I will be supporting very affirmatively what was the decision of the committee, in particular what was the result of the compromise that we had pertaining to qualified immunity, and this whole body of work, which includes the revocation of peace officers and what we need to do in training. So the consensus had a lot to do with, holding those accountable for their misdeeds. And I'm very proud. I'm very proud of the work accomplished under the leadership of Senator Fields and the various chairmen and vice chairmen. I know everyone else was mentioned, but no one mentioned Senator Hewitt, and we're very proud of her actions as well. So just like you come together today, to hear for the first time what actually went on, there were many meetings, many subcommittee meetings, many things which amounted to that body of work which I referred to. But at the end of the day, it's how people came together, and there was a better consensus than I envisioned. Also, there was a better consensus of people coming together. So I just had to tell you that that's where we stand, and that's what we will ask our sheriffs to support starting tomorrow. So we'll start with that committee and then wound up before an at-large meeting of all of our sheriffs. And it's certainly my hope to come before the legislature in April and to tell you that we have supported what was done.
Thank you, sir.
Thank you, Representative Jefferson. Representative Freeman.
Thank you, Mr. Chairman. First, let me just thank the Sheriff's Association for working on this issue as well, and I appreciate all the hard work. Ms. Derriman, you said when with these changes that it would be considered, it had to be considered unreasonable by the finder of fact, then it proceeds. I'm a process kind of person, so I'd like to understand what you're envisioning a case under this new law. How would that work?
So currently, the Kyle factors are used. It's I have them right here. Some factors the court are going to consider are the known character of the arrestee, the risk and danger faced by the officers, the nature of the offense, the chance of the arrestee's escape, the physical size, strength, and weaponry of the officers. And there's a couple of more factors that the court will consider when it comes to reasonableness as far as use of force goes. And then after that, we have now put on the books as an instruction to the court that's the legislature's will that if someone acted unreasonably, an officer acted unreasonably, and these factors are found, then the court can determine the liability from there.
Okay, so under those those factors will be used in the case to determine reasonableness, and if the finder of fact finds that it's unreasonable conduct under those facts, and things that you just read off the criteria, then they could award damages and so forth, just like in a regular tort suit.
Correct. The court could do that based upon the facts and the circumstances.
Okay, thank you very much. Thank you.
Okay. Thank you, Representative Freeman. Representative Carter.
Those criteria, where will one get that?
I can send it to you, the Kyle factors. It's a case.
Thank you.
Thank you. And Representative Carter, in the memo that Ms. Smith and Ms. Pearl put together, they have under Section D on page 7. It's from Kyle versus City of New Orleans. I think that's must be a Louisiana Supreme Court case.
Right, thank you.
So, all right, thank you. Representative Freeman again? Sure.
And this could go to Rep. Jordan as well, but the problem we had before was this court created jurisprudence, And we're still, with this law change, we're still relying on court-created jurisprudence, right? Did y'all give any thought to codify the Kyle factors into the law? Or because jurisprudence can change at any moment in time. So are y'all concerned in any way, either side, that those factors could ultimately change rather than codifying those factors under the law?
I don't want to speak for Representative Jordan, but they're mentioned in dozens of cases, so I think that it's clear to the court to use those.
Okay. Thank you.
Thank you. And Mr. Renat says, thank you. We had a very good conversation last week, and on a lot of the issues that y'all have spoke to in dealing with the post certifications, as well as differences in, at-will employees of sheriffs versus people who are officers who are employed and protected by civil service. So there's a lot of different moving parts, and there's not a one size fits all, and not every department is the same. But and also the risk pool, and you talked about how, and I think this dovetails with Professor Diamond's testimony about market factors, is if you have a sheriff's department that is not doing enough to make sure that they have properly trained and qualified officers who are following the constitutional policing practices, then they're going to end up getting sued, and there will be liability for the risk pool, and they may find themselves without coverage under your plans. Is that correct?
That's correct. And our risk program has as members approximately 45 of the sheriffs, and that is how we manage our risk and our losses, and we do so with promoting training within the sheriff's offices, because we don't want to be subject to those lawsuits. We'd rather be proactive. And I'd be remiss in not telling you that the chairman of our Legal Affairs Committee is Sheriff Greg Champagne, who happens to be not only a past president of our organization, but the past president of the National Sheriff's Association. So instilled in our membership with the Sheriff's Executive Management Institute, in which we had Professor Diamond actually come do the training for our sheriffs, is the acknowledgement within that body and with all the sheriffs that whatever we can accomplish with advanced training, advanced in-service training, there's provisions for in-service training in the recommendations as well, that we're gonna do better in policing. We're gonna do better in being sheriffs, and please let me state also that the recommendations that came before you had the support of the state police, and also our Police Chiefs Association, the Louisiana Association of Chiefs of Police. So we are, as sheriffs, responsible for our individual budgets. We're responsible for the totality of the office, and certainly better training alleviates many of the problems that have been discussed.
Thank you for your participation. I'll just say Sheriff Champagne is our sheriff in St. Charles Parish, and in his more than 2 decades, I think he's going on to 3 decades of service, he has changed the department in such positive ways with the level of training and professionalism that he has instilled. It betters everyone, and not that we're immune from having a bad apple once in a while, but it's very rare that you'll ever see anyone from St. Charles Parish being subject to bad policing practices. But again, I wanted to give that shout out to Sheriff Champagne and his department. All right, with that, thank you all very much for coming, Ms. Dearman. We have President would like to speak, Donovan Livicari from the Louisiana Fraternal Order of Police. Good morning.
Good morning, Representative. Thank you for the opportunity to speak here this morning.
Just identify yourself.
I'm sorry. My name is Donovan Livicari. I am the General Counsel for the Louisiana Fraternal Order of Police. I am from New Orleans, so I typically operate out of New Orleans, but we have 6,000 members, more than 6,000 members across the state. I was asked to be here today by the president of the Louisiana Fraternal Order of Police, Darryl Basco, who participated on this task force. And since he has already been able to address some of the legal concerns that we had about qualified immunity legislation, I just wanted to quickly address some of the practical concerns that I have. One of the things that we've seen in New Orleans in trying to replenish the ranks of the NOPD is that police officers these days are more than happy to travel to find new employment. I think that we just have to be aware of possible unforeseen consequences of changes to this type of legislation, because I think that officers would, or potential officers, would easily decide that they wanted to go to Texas or Mississippi or Arkansas if those states offered the type of protection that we're talking about taking away from officers here in Louisiana. The officers aren't the ones with the deep pockets. Any of these types of actions that are likely to ruin the officer and their family, and with that type of risk, I'm not sure that that's going to. I certainly don't think it'll positively impact our ability to recruit the type of law enforcement professionals that we want to recruit. It's just, I think, a practical consideration that law enforcement officers who do not want to become engaged in any type of deadly force incident. I mean, nobody wakes up in the morning hoping that they are going to get in a deadly force incident that day. But we realize that it's a practical possibility of being a law enforcement professional. So with that consideration, the possibility of your kids not being able to go to school and not be able to have a house for your family, these types of things are something that professionals are going to consider when deciding where to seek employment. And so I think that it's something that we have to keep an eye on closely, and to see what type of impact this type of legislation would have on the recruiting abilities of our agencies across the state.
Okay. Thank you. Representative Johnson for a question.
Thank you, Mr. Chairman. This is not directly related, but it's a question I have. Since you're here, I'd like to try to ask you about is I'm hearing from every agency, local, parish, state law enforcement. They can't find people. They can't keep people. And just what's your appreciation as to the problem? Is it money? Is it morale? Is it the stigma that some are attaching to law enforcement? What is it?
Before you answer, I just want to remind members, let's stick on topic, but I can see some, I was going to ask the question of, do you see low pay versus this issue of possibly losing a certain amount of qualified immunity as being a bigger issue. But with that,
Thank you, Mr. Chairman.
Mr. Representative Johnson was asking it in a little different way.
I'll pass you my next question. You
right,
worded
thank
it,
you.
you worded it better than I did, but that's why you're the chairman.
Those are both excellent questions. And I, if I could identify the exact reasons that we lose so many police officers, then maybe we'd be able to fix the problem. But there's certainly, I mean, I speak to graduating police recruits on a regular basis, and nowadays there's in every class people who raise their hand and say that they're only there to get the training and move on to federal employment or move on elsewhere. And certainly money's a consideration, but it's clearly not an overwhelming consideration for everybody. I think, though, that the assumption of risk is something that everybody understands on some level. And, even if the risk isn't exactly what people think that it is, it's their perception of what that risk is that really drives people. So I think that it's a confluence of factors. I think that this could develop into a factor, though, if going to work meant carrying that risk every day. I mean, it's bad enough that families wonder whether their law enforcement professionals are going to make it home at the end of every day. But to throw this on top of it, I think that it potentially makes it much worse.
Thank you.
All right. Thank you, Representative Johnson. Mr. Livercari, but you're not suggesting that, requiring the finder of fact in the proceeding to find that it's unreasonable, that is that an issue that you feel can be problematic?
We're going to be bound to the decisions of judges across the state until we get rulings from the Supreme Court, and who knows how these rulings are going to go. Judges are influenced by all kind of different factors in making their rulings, and it's difficult to tell what level of consistency we're going to have, at least for a while, until we can narrow everything down enough. Yeah. So it's hard to say.
No, I understand, and I certainly valid concern. But I'd also point out if judges are interpreting the law in a way that is inconsistent with what this legislature intended it to be, if it's opening up the floodgates, and we didn't allow. We don't want that. We can then make some more, impose some standards, and just as we had said, why not make the Kyle standards, statutory? But we certainly can tighten things up. I mean, I know we're always entertaining legislation in this committee in civil law. When in the middle of a case, in fact, somebody doesn't like the way Court of Appeal or a trial court has ruled, so legislation is enacted to try to undo that. So, I do know, but I appreciate that the concern, and I'm happy to be able to hear the both sides of the issue.
Thank you.
And with Representative Freeman for a question.
Thank you, Mr. Livercari. Does your organization have an issue with the current jurisprudence that says that if it didn't happen before, you can't find them liable now? Philosophically, do y'all have a problem with that?
No, and I think it's important to remember that this qualified immunity isn't just about law enforcement, right? The qualified immunity is about public servants across the board. So, no, I think that the application in its current form has served us fairly well. Again, I don't think that when we're talking about civil actions, the officers are not the ones with the deep pockets, so that they're not the ones that are going to get raked over. I mean, it won't take much to empty those shallow pockets, but ultimately the burden could end up being more on the agencies than on the individuals.
Well, that brings me to my second question. Wouldn't vicarious liability take over? I mean, wouldn't the department be ultimately responsible for its employee?
I do think that that's certainly an issue that's going to present itself. I don't see how you get around it.
I mean, because if you're going to file suit and it's just an officer who makes $40,000 a year, that's not where they want to get their money from. So they're going to be trying to get it from the department under vicarious liability, which ultimately they may have insurance. I'm sure that's going to create, if there isn't an insurance market now, there will create an insurance market for it then if this passes. So I understand your concerns from the police officer standpoint, but I'm not so sure, practically speaking, that's a reality. But that's just my opinion.
Thank you.
Thank you, Representative Freeman. And my understanding, and thanks for staff pass me a note, the vicarious liability would apply to the acts of an officer who's trying to bring up qualified immunity, except for an intentional act on behalf of the officer. Is that your understanding?
Yes, but I think that the qualified immunity also applies to the police chief and to the people in between as it stands now. I'm not sure how the current legislation would affect the police chief as far as him being vicariously liable for the actions of the individual officers in his agency. But if it opens that door, then I think that we have a framework that exists across the board for public service, public servants in general, and it operates fairly well. And I understand that we want to address the issues that are raised, that brought this whole matter to light. And I'm not trying to, by any way, suggest that we should not address those concerns. My only concern really is the impact that this potentially has on our agencies and on the individual hardworking individual police officers.
Thank you, Representative Jefferson, for a question.
Just real briefly, I'm a little confused. So you're saying what we have in place right now suffices?
I think that it serves its purpose. I understand I understand the arguments against it, though.
Okay. So, and one of the reasons that really impressed me as it relates to this process, Representative Jordan initiated something, people listened, it went through the process, didn't quite get over the hump, but because it was one of those issues, individuals came together and said, we may not agree in totality, but we're going to sit down at the table and we're going to come at some solutions to the problem or to the situation. So I guess my question to you is, as it relates to the recommendations, are you concerned with the totality of the recommendations or just the instance that now, once the trial fact can proceed, if that standard has been breached, is that your concern?
Well, as I stated at the beginning of my comments, that our president, the president of the Louisiana Fraternal Order of Police, participated in this task force that came up with these recommendations. So it's not necessarily the suggested language that that I'm opposing here and now. My reason for being here is really just to say that I think that we need to pay attention moving forward for these potential adverse consequences that may have been unforeseen at the time, or something that maybe wasn't considered, or whatever the case may be.
Okay.
That we have to be in a position to recognize these things in the future and make whatever changes are necessary to adjust for it.
And it's also quite plausible with the recommendations that the problems that you foresee may not occur as well.
Certainly.
Okay. Thank you so much, Mr. Chairman.
Thank you, Representative Jefferson. Thank you, Mr. Lepicari, for being here. I don't see any other questions from any other members. So,
thank you.
All right, great. Thank you. I think we have two other cards. President will provide information if requested. Jim Kraft, Louisiana Commission on Law Enforcement, and present and will provide information if requested. Rebecca Taylor, Post Programs Manager, Louisiana Commission on Law Enforcement, Post. So if anybody has any questions of those two individuals, I don't see any questions. If there's anybody else that would love to come forward to speak, and if not, then perhaps we can entertain a motion from a member as to what would the subcommittee like to do. It would be a recommendation to the full Civil Law Committee. And so we have Representative Jefferson.
Thank you, Mr. Chairman. At this time, I move that we move favorably, transmitting these outstanding recommendations to the full Civil Law Committee.
So Representative Jefferson's motion is to concur in the recommendations from the SCR-9 task force as to the suggested language to RS 927.93.1D, adding section D, and 92798.1, it would be subsection E, and then section 2800.10, and that would be section C. And I think all three of those sections have the exact same language. That's your
That is
motion?
correct, Mr. Chairman.
Okay. And Representative Johnson for a question?
I just have a question.
Sure.
This was Senator Fields' task force that he set up, and all the stakeholders were a part of that, were they not? And all we would be doing is making it as a recommendation to be included as legislation.
Oops, sorry.
Well, it's my understanding that the full Civil Law Committee would hear these recommendations and then make decision as the process will continue.
I mean, at this point, it's only a recommendation. No legislation has been sponsored yet, but it would lead to that for perhaps. Okay. All right. Thank you.
All right, I finally figured out how to work the microphones again, just so when the colloquy ended. So, all right. Representative Jefferson has made the motion for the recommendation, and we don't need a second. But is there any objection to that motion by Representative Jefferson? Seeing none, those recommendations are adopted. So those recommendations will go to the full committee, and so we'll hear that probably maybe during the session, or we may have a meeting beforehand. But I think without anything else on the subcommittee's agenda. Sure, Representative Freeman, point of order.
When you say that it's going to come to the full committee, would that have to come in the form of a bill?
No, not necessarily. So we make the recommendations to the full civil law, so the full civil law committee can then either adopt these recommendations or change the the full committee could reject the recommendations of the subcommittee. As to the proposed changes, someone would still have to sponsor legislation and introduce legislation.
So before the changes can be made in the law, a bill would have to come before. Okay.
Correct.
I'm just trying to understand the process.
Sure, thank you. Representative Jefferson again.
That was my point, Mr. Chairman, just to say that still someone could, propose, because the full committee could say, no, we don't like these recommendations, but still Representative X or Senator so-and-so could still file legislation.
And some representative could also file something that goes way beyond this or does something less.
Yes,
So,
sir. Thank you.
So